Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. Well, we're almost at the end of what has been an unexpected year, to say the least. This time last year, I don't think any of us would have anticipated a global pandemic sweeping through every nation on Earth. Despite this, there has still been time for 2020 to provide a few final surprises for the pensions industry. We almost had a brand new Pension Schemes Act, but alas, that will have to wait until next year. I think we all appreciate that there are other, more pressing matters keeping the government busy at the moment. The other one, and the subject of this podcast, is the High Court decision in the high-profile, well, for the pensions industry at least, Lloyds Bank pensions case on the equalisation or levelling up of guaranteed minimum pensions, or, as we more fondly know them, GMPs. In case you are unfamiliar or just want a brief recap, GMPs were a form of statutory minimum pension that employers were required to provide if they contracted out of the state earnings-related pension scheme, known as SERPs, and was the additional earnings-related pension, available to some earners on top of the basic state pension. GMPs replaced that part of the state pension and were required between the 6th of April 1978 and the 5th of April 1997. GMPs, by design, were calculated differently for men and women, which means that the total benefit can also be different. The latest High Court decision will be the third Lloyds Bank judgment on this far-reaching topic. You may remember the landmark Lloyds Bank decision in October 2018, where the High Court held that pension schemes had to equalise benefits as between men and women for the unequal effect of GMPs. For a number of years prior to this, UK pension schemes had been grappling with the issue of whether, and if so how, scheme benefits should be equalised for the effect of unequal GMPs. This decision affected members and beneficiaries of members who had built up a GMP between the 17th of May 1990, being the date of the landmark EU Barber judgment, and the 5th of April 1997, being the date that GMPs ceased to accrue. However, the 2018 judgment left some unanswered questions, including what to do about past transfers. If a transfer out had been processed before October 2018 and no allowance had been made for GMP equalisation, did it need to be equalised now? And if so, who was responsible for levelling up the amount transferred? The transferring scheme or the receiving scheme? Well, we finally have a decision. Of course, some of the judgment is specific to the Lloyds schemes, but it does helpfully lay down some important general principles which all schemes should take note of and consider carefully with their advisors. Before moving on to the recent judgment and what it specifically said, it's important to understand that many transfers out are completed under the cash equivalent basis provided for by legislation, namely the Pension Scheme Act 1993. In the recent Lloyds judgment, the High Court held that under the cash equivalent transfer legislation, trustees have a duty to pay a correctly calculated transfer value. This means allowing for GMP equalisation. If the trustees fail to allow for this GMP equalisation, then the trustees had breached their duty at the time when the transfer was made. No rule from a trustee can discharge the trustees from liability, since the cash equivalent legislation overrides scheme rules. The cash equivalent legislation mentioned before did not provide that the defective transfer value calculation was final and binding, or discharge trustees from liability in respect of any shortfall in the past transfer. Therefore, the transferee, i.e. the member who requested the transfer, could require the trustees to pay a top-up transfer to the receiving scheme equal to the amount of the shortfall plus simple interest at 1% above base rate. However, the transferee could not require the trustees to provide a residual benefit, such as a pension amount held in the transferring scheme, and equally the trustees could not compel the transferee to accept such a benefit. Having said that, the court recognised that it may be possible to provide a residual benefit if both parties were to agree to it. Also, if a receiving scheme was unwilling or unable to accept a top-up transfer, an appropriate solution would need to be agreed between the transferring scheme trustees and the transferee privately. If they were not able to agree, a solution could be imposed by the courts, such as the payment of compensation by the trustees to the transferee. Now, I can almost hear some of you asking, but what if a member signed a transfer form when completing the transfer out, which said the trustees had no liability following the transfer? Well, the court considered this as well. In the Lloyds schemes, members had signed such forms discharging the trustees of liabilities on transfer out. The court looked at these forms and decided, given the way the forms were worded, that the trustees were not discharged of their liability. While the forms included a discharge of liability as regards benefits, a top-up transfer like this did not constitute a benefit. Another question which was considered by the court was whether there is a time limit on when a former member can bring a claim against a scheme. So essentially, can a member bring a claim against a scheme of which they were a member over 20 years ago? The court decided that top-up claims from transferees were not subject to any statute of limitation period. In the Lloyds schemes, there were even certain forfeiture provisions in the scheme rules. However, the court held that claims were not subject to these forfeiture provisions. So it's clear that a number of past transfer payments will need to be revisited. The question therefore becomes, should trustees just sit back and wait for former members of their scheme to come forward with claims? On this, the court said no. Trustees have a duty to be proactive. However, the court did not go as far as saying that trustees would have to identify and top up every relevant past transfer. Instead, being proactive in this context means considering their obligations, rights and remedies arising from the judgment, and then deciding what to do in light of the particular scheme. So far in this podcast, I have been focusing on the transferring scheme, but what about the scheme that received the transfer out? Well, if the transfer was to another defined benefit scheme, the receiving trustees might have their own duty to equalise. However, the existence of such a duty makes no difference to any top-up duty of the transferring trustees, i.e., both duties are concurrent. It is worth mentioning that the court did not address the possibility of indemnities or disclaimers which may well exist between a transferring and receiving scheme within the transfer documentation used at the time. All the comments I've made so far relate mainly to statutory transfers, i.e. those where the trustee had a statutory obligation to carry out the transfer out once the requested member had met the criteria. But what about other types of transfers? Well, in the context of transfers made under scheme rules instead, the court considered two types. One, bulk transfers without consent when members to a scheme had been transferred to another scheme as a group and were provided with mirror image benefits in the receiving scheme. You see this quite a lot on a corporate merger or acquisition deal. And two, individual rule-based transfers. These are transfers made at a member's request other than under the cash equivalent transfer legislation. So firstly, for bulk transfers without consent where mirror image benefits were credited in the receiving scheme, the court held that provided trustees met the requirements of the preservation legislation at the time, they had been discharged of their liability to top up these past transfers when the bulk transfer took place. It is important to emphasise here that this is only in the case where mirror image benefits have been provided to members in the receiving scheme. It's not to all bulk transfers. Secondly, for individual rule-based transfers, the court considered the rules of the Lloyds schemes, which offered a considerable amount of discretion to the trustees as to how non-statutory transfer values were calculated. In that context, the court held that a transfer value could not be said to have been incorrectly calculated merely because allowance had not been made for GMP equalisation. Instead, in order for a transferee to challenge the amount of a past transfer out, they would need to show that, when calculating the transfer value, the trustees failed to consider a relevant matter, like GMP equalisation, and that this failure amounted to a breach of duty, and the calculation should be set aside by the court. The latter judicial step is required since, as a matter of trust law, a failure of a trustee to consider a relevant factor in calculating a transfer value makes the decision voidable, not automatically void. We are yet to see if Lloyds will appeal this judgment, but regardless, schemes should consider the judgment's implications with their advisors. It seems to me that there are 5 key issues for any scheme coming out of this decision. 1. Transfers dating back to 17th of May 1990 are potentially in scope. Trustees may not necessarily still hold records of transferees, amounts or details of receiving schemes from that time. The legal position will depend on whether it was a statutory or non-statutory transfer, the relevant scheme rules, and any forms signed by the members at the time. Therefore, an appropriate fact find of all these items should be undertaken by trustees. If you are a trustee of a pension scheme, speak with your administrator or legal advisors to get an idea of the best way to approach this exercise. 2. The court said the default remedy was to top up the past transfer out by an amount it fell short by. However, this might not always be that easy to implement in practice. The original transfer value will need to be recalculated, including applying basic interest and allowing for inflation. An agreement will need to be reached with the receiving scheme as to the process for paying any top-up amount. 3. Trustees will need to be open to exploring alternative remedies. For example, what if a receiving scheme will not or cannot accept a top-up? An alternative agreement will need to be reached with the former member directly. 4. There may be tax implications arising from any transfer top-ups or alternative remedies. Specialist tax advice may be needed. Number 5, and finally, the court mentioned the need for trustees to be proactive. Trustees should consider the legal position and the practical reality of processing and implementing past top-ups now. Just how far trustees should go to identify and reopen historical transfers is as yet unclear, and therefore it is all the more important to discuss these issues with your advisors. Over the coming months, we will no doubt all start to hear about how schemes and their advisors are handling the challenges and how they are approaching the unanswered questions, so watch this space. One thing that I don't think is in question though, is that each and every one of us is looking forward to a well-earned festive break. So I hope you all have a wonderful time, whether you are celebrating on your own, over Zoom, or, depending where you live, in a small Christmas bubble. I look forward to speaking to you all again in 2021. And in the meantime, happy holidays. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.